They can now take away your citizenship, even if you did everything right. A new wave of denaturalization is underway across the United States, quietly reshaping how citizenship is treated under the law. This is no longer theoretical policy. The Department of Justice, under the Trump administration, has revived denaturalization efforts with expanded legal authority, broader definitions, and billions of dollars in fresh enforcement funding. For naturalized citizens who thought their journey ended with the oath ceremony, this new reality is unsettling. Citizenship, once considered permanent, is now legally vulnerable again. $170 billion in enforcement has changed the game entirely. The federal government has unlocked over $170 billion for immigration enforcement programs, much of which is being funneled toward investigations, legal actions, and digital surveillance. Part of this allocation includes the reactivation of a DOJ unit focused on denaturalization, which was previously dormant but is now aggressively pursuing civil revocation of citizenship. These resources allow the government to cross-check naturalization applications against old visa filings, arrest records, tax returns, and even social media activity going back more than a decade. Denaturalization isn't just about fraud anymore. Historically, denaturalization was used only in cases of extreme fraud, like war crimes or fake identities, but the legal criteria have now expanded under revised internal guidelines. According to these updates, citizenship can be revoked based on national security concerns, unresolved criminal charges, gang affiliation, tax violations, or material misrepresentation at any immigration stage. The most troubling change is the phrase used in the new DOJ memo: cases will be pursued if the person is sufficiently important, a term left completely undefined. Even pending charges can now put citizenship at risk. One of the most radical updates allows denaturalization based on criminal charges that have not resulted in a conviction. Even unresolved or pending charges can now trigger proceedings. This is a significant shift from the previous threshold, where only final convictions were relevant. Now, simply being charged with a qualifying offense is enough to begin review. Legal experts warn that this opens the door to politically motivated actions, where someone's naturalization is challenged despite the absence of a criminal verdict or wrongdoing. What the legal process actually looks like. Denaturalization cases are not criminal. They are civil lawsuits filed by the Department of Justice in federal court, usually initiated through a referral by USCIS or ICE. Because they are civil, the burden of proof is lower. The government only needs to meet the clear and convincing evidence standard, far easier than beyond a reasonable doubt. If the case involves immigration fraud or concealment of facts, then the court may apply the higher criminal standard. But in most cases, the lower threshold is used. Examples of denaturalization triggers in 2025. Several new categories are being used to justify denaturalization. These include people accused of financial crimes, falsely claiming to be single on visa petitions, or hiding affiliations. Individuals who may have supported banned organizations, failed to disclose arrests during green card processing, or lied about employment history during asylum applications are also under scrutiny. In some cases, the government is reviewing whether someone failed to mention minor infractions or administrative charges, arguing those omissions were material to their immigration journey. Why even U.S.-born citizens are starting to worry. U.S.-born citizens cannot be denaturalized, but concerns are rising after the Supreme Court reopened discussion on birthright citizenship and its constitutional scope under the 14th Amendment. Although the Constitution protects citizens by birth, new state-level bills and executive discussions are creating confusion about how far federal agencies can go under national security claims. More troubling is the scenario where a parent is denaturalized, which may then call into question a child's citizenship that was derived from that parent's naturalization process. This is not just about criminals anymore. The same pattern that occurred with deportations is now unfolding with denaturalization. The government initially promised it would only target criminals, but the definition keeps expanding. Visa overstays, minor fraud allegations, and administrative errors are already being used to place individuals in removal proceedings. Denaturalization follows that same slippery slope model. What begins with national security cases can quickly become a tool used more broadly against people with no intent to deceive, just flawed paperwork or unclear legal histories. For Americans already stripped of citizenship in July. Within just 3 weeks, 4 Americans have already lost their U.S. citizenship under this revived enforcement model. Most of these cases involved criminal elements, but not all. Attorneys representing one individual say their client was accused of misrepresentation, even though the facts were publicly available and disclosed during prior interviews with immigration officials. This signals an aggressive stance, where even minor inconsistencies from years ago could now result in legal action to revoke a person's naturalized status and strip them of U.S. rights. Civil doesn't mean safe, it just means faster. Many immigrants assume that because denaturalization is civil, the risks are lower. But civil court proceedings often move faster and offer fewer protections than criminal trials. There is no jury. The decisions are made by a judge. And because the evidentiary standard is lower, a strong defense becomes harder to mount without immediate legal support. The individual also risks becoming stateless if their original country does not re-accept them after denaturalization, something that has already occurred in a handful of 2024 cases. What naturalized citizens should be doing right now? Immigration attorneys are advising naturalized citizens to review their immigration records, especially their green card, asylum, or marriage-based filings to ensure there are no unresolved gaps. People should also avoid public associations with political groups that are considered subversive or foreign-linked under U.S. law, as these may be misinterpreted under the new framework. More importantly, citizens should consult an immigration attorney if they suspect there were any mistakes or omissions in their application process, even if those occurred many years ago. Final thoughts: this is just the beginning. What we're seeing now is just the start of a far more aggressive era in U.S. immigration enforcement. Citizenship is no longer viewed as permanent by default. What used to be a rare and controversial legal action is now becoming a normalized strategy, supported by new legal definitions and a massive expansion of federal enforcement powers. If you're a naturalized citizen, or your loved ones are, now is the time to stay informed, stay vigilant, and understand the laws that are changing rapidly in 2025. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, see you in the next video.